concerns. So, we had a conditional use hearing the other evening, and it was a request, a permitting request from, EQT regarding the Sarah Well site, and, there was some concerns regarding, water and concerns on potentially contaminated water runoff. And so we wanted to make sure we fully address this tonight. And I want to open that discussion up to board members who were present at the conditional use hearing. And in fact, why don't, sir, I'm sorry, I forgot your name.
Jacob.
Would you like to speak first so you can maybe, and I'm sorry, Joe Raposki, do you have comments as well?
I have a comment to make.
Okay.
Joe, why don't you go first? I'll follow you, sir.
Well,
I'm sorry, Joe, could you list your name and address for the record? Thanks.
Joe Raposki, 155 Lobbs Run Road, Finleyville, PA. I have a question about the permit. I came up the day before and I started to review the application, which you saw how much was in there. I got some of the things I was interested in. But this permit, what I want to ask you is, this requiring EQT to lease the properties, is that in there?
You can't make that requirement.
It's not in there.
It's not in there.
Okay, because after the meeting, the next day, somebody had put in my mailbox, because they know that I'm involved in it, about a law firm in Pittsburgh that is filing class action against EQT for drilling without leases. The people did not have leases. I only wanted to know whether that's in there. If it's not in there, it's no problem. I mean, it'll give me something to do it, so I just wanted to know that.
Okay, you feel satisfied with your answer that you got the correct
Yeah,
answer?
it's
Okay.
not.
And the law is, they cannot run a well bore under property that they don't have under lease.
Right.
That becomes a criminal and civil trespass.
Yes.
So that would be the issue. You know, is there a 100-acre farm they don't have a lease on, and then you're able to determine that one of the well bores went underneath that unleased property? That's a big problem for the drillers.
Well, we have that with the gas storage, that they never got easements or
Right.
leased it.
I'm aware of that before you
So-
talked about that.
I know what you're saying, it's just that I know EQT's treating you people right and everything in the township, but they don't treat the property owners right, and that's what I want to.
This conditional use application only pertains to the surface drill pit. Has nothing to do with the subsurface leasing of oil and gas.
Okay, I understand that. I just wanted to make it clear to myself.
If I may say, and I'm sorry, I don't want to jump in front of your public comment, I'm sure. I heard what you said about they're treating the township right. There's been 3 conditional use hearings, if I'm correct, prior to this one, and they were rigorous. And it was, I think, in my opinion, Harshman's firm following of the ordinance and to the letter of the law, the way he reads things and requires anybody doing business here to do to the letter, that we went through a lot of struggle to get where we're at, to where, like, the conditional use we had the other night seems like it flowed a little bit more easy as far as our engineering goes. I think there's a standard built here over the years on what the township expects.
In the previous 3, maybe even before conditional use hearings, in those approvals, this board attached 31 conditions to the approvals. So, I mean, dealing with just about every issue that the public was concerned about, that we could, in some fashion, regulate or give some control over. And things that the board and that we have come up with through our experiences in other townships and dealing with. And these were conditions that EQT accepted. They didn't challenge it. And at the very minimum, if this board approves the issuance of this conditional use permit, our recommendation would be that we would start with those 31 conditions that have been standard in every one of the applications.
Gary, would you be able to speak
Gas Act. It's referred to as Act 13. And that has been challenged different times in the courts. The initial challenge was that that portion of Act 13 that prohibited townships from regulating the aspects of the drilling process that dealt with township assets, such as roads and water and forestry, was unconstitutional. That we had not only not only a right, but a fiduciary obligation to protect those resources. So that was the big Robinson Township challenge, and all the way to Supreme Court of Pennsylvania. And what came out of that is that there are certain areas that, yes, we can speak to. The bulk of drilling operations, however, are preempted because there's a state statute. A local ordinance cannot override a state statute. If the state says, this is what we're going to regulate, and these are the terms and conditions, we cannot do anything to preempt that. And the policeman is supposed to be the DEP over those issues. You need to understand that oil and gas drilling is a land use. And under the law of zoning, every zoning ordinance needs to provide for every conceivable land use. The good ones all the way up to the bad ones. Because if you don't provide for that land use, the law of exclusionary zoning comes into play, and that particular applicant developer gets to put that use anywhere they want. That's the purpose of zoning districts. That's the purpose of permitted uses versus special exceptions versus conditional uses. And that's also the purpose of residential to commercial to industrial. And you try to put all the bad things in industrial. Well, the courts have already said oil and gas drilling can take place just about anywhere in your township. You just can't restrict it to 100 acres of industrial zoned area within the township. So once a land use is identified, we've classified it in our ordinance, and almost every other township does the same, as a conditional use. That means they have a right to do it, subject to the conditions that are set out in the ordinance. We have a significant number of conditions that are there. So if their conditional application meets the standards of our ordinance, we can't deny the conditional use. I mean, I know there's some property owners, especially if I own property right next to a drill pad, I would say, I want you to turn this down. I don't want this to happen. We don't have that ability. If they satisfy the conditional use provisions, we're required to give them that conditional use. Now, the stepping stone becomes, can we attach additional conditions? Those conditions have to be based upon fact and or scientific study. It can't be based on conjecture. It can't be based on, well, we want them to do this just in case. I'll give you a litany of cases that say those types of hypothetical conditions without definite demonstrative evidence will be stricken by the courts. And one of the things that guides us, we've done a lot of these. We've had land use appeals that were filed by different drilling companies objecting to some of the conditions. And for the most part, they've been resolved. But if we were to attach unreasonable conditions that aren't based on the record or the evidence, and if EQT appealed, we already know where it's going to go. It's going to the Washington County Court of Common Pleas. It's going to be assigned to Judge Michael Lucas. He handles all land use appeals. We have an extensive opinion